Okay, so welcome everyone to our first online Co-op Ask the Expert event. So my name is Ellis. I'll be hosting the session this evening and I work in Co-op Life Services. So that encompasses funeral care, legal services and our insurance business, which is where I work, specifically managing our travel insurance partnership. So someone can't hear me. Can everyone hear me? Yep.
Yeah, we can hear you.
Perfect. So I've got a bit of housekeeping to start off with. So tonight's event is being recorded for those who couldn't make it. So please be mindful if you do have your camera on, and if you'd prefer not to appear on the recording, you can leave your camera off. You'll also be able to find the recording of tonight's event available on our YouTube channel in case you want to watch it back or share the advice you get with friends and family. And we'll share details of that in an email alongside our feedback survey on the 12th of March to all members who signed up to this event. So tonight's event, exclusively for Co-op members, is on the theme of life planning, and we're here to give you access to expert information to support you through major life changes. This is something we've heard a lot about from our members, and we want to do a series of these events throughout the year, so your thoughts and feedback on tonight is really appreciated and will help us shape future events. So we know life planning can mean lots of things to different people, and that's why we're starting here. So we'll be covering a range of topics, and that's based on what our members have already told us, and we'll give you the chance to ask your own questions later on the call. We've received a lot of submitted questions, so sadly we won't be able to get to all of them. And we've also received a number of questions around things like financial planning, such as investments, pensions and ISAs. So we're unable to answer those questions, but there are a number of free financial help services that are available. The Money Helper service is one example of those, and we can pop the link to that in the chat. So we're joined today live on the call by Ben and Matt. Give us a wave, Ben. Give us a wave, Matt. Brilliant. So they're our resident Co-op experts who will be answering the bulk of the questions. We've got Azra with us. Give us a wave, Azra, if you're on screen. And she'll be running some polls for you to get involved with in the chat, posting useful links and leading on the Q&A later. And we'll also have other Life Service colleagues in the chat who are able to pick up some questions as we go. And last but not least, we have Becky and Terry on today who will be helping to support the event, sort out the tech and make sure it runs as smooth as possible. So we wanted to make sure tonight's event is truly shaped with members in mind. So the first section will cover some of the key themes and questions provided in advance. We'll then move on to that live Q&A where you can submit your own questions to our experts. Now, we won't be able to offer specific individual advice, so just bear that in mind. And please be conscious about sharing any personal information in the chat. As we go through the event, feel free to drop any questions you like into the chat. We'll be sure to pick them up and they can be asked on your behalf later on. However, when we do get to the Q&A, you'll also be invited to come off mute yourself and ask your questions if you prefer by using the hands up function on Teams. Now, the hands up function is in a different place depending on what device and browser you're using, but it should be easy enough to spot. Any problems finding it, let us know in the chat and Becky and Terry will do their best to help. And we'll be sure to let you know when it's time to use that function. So just please wait for the Q&A. And finally, we'll end the event with a prize draw where one lucky member on the call will win £50 on their Co-op membership card. So please stick around to the end to be in with a chance of winning. So we are hoping to be done by about 8 p.m. But if we still have questions to get through and people are happy to hang on, we may stick around for a bit longer if you've not had enough of me by then. So let's dive in. I'm going to ask Ben from Legal Services to step up first. Ben, if you'd like to introduce yourself and let us know what you do, and then we'll come to you for the first question.
Yeah, thanks, Alice. Hi, everybody. My name is Ben Schofield and I work in Co-op estate planning. So I'm a technical lead over in the wills, powers of attorney and trusts division. And basically I spend day to day just keeping the paralegals and the other lawyers around me up to date with the law, what's new on the horizon, and just to apply that into the work that we do for the clients who are looking for wills and powers of attorney mainly.
Right, thanks, Ben. So I'm going to come to you first with our first question, and I'm going to ask you two at once because they're kind of relevant to the same point. So we've been asked by Jane in Glossop. She'd like to know if it's possible to put her property into a trust so that it can't be used to pay for a care home in later life. And then Adele in Barnard Castle has asked, should I put my house in my daughter's name to avoid losing it to care home costs? What are the pros and cons?
Great. OK, thank you. So the first question then about can I put my property into trust to avoid it being used for care fees. I think the first thing to point out is that specifically covered in the Care Act 2014, it talks about deliberate deprivation of assets. So one thing that you're not allowed to do really, is to deprive yourself of an asset in the hope that you're then protecting it from being used to assist with things like care fees. So you're not actually allowed to move your house out of your name to avoid it being used for care fees. There's other finer details around that, in the sense of it depends on your health at the time and if care is foreseeable. So we basically we don't take on that kind of work or assist with that if it's primarily being used to move a house out of ownership in the attempt to avoid it being used for care. It's actually, I mean, against the law sounds a bit strong, but the Care Act is a law, and it basically says in there that you can't do it. So it's, yeah, unfortunately, that's not something you can do. Tying that into placing my property into the name of my daughter for similar reasons, what are the pros and cons? I mean, there's very, if any, pros to that. You've got the same, you're going to fall foul of the same rules in the Care Act of deliberate deprivation of asset. So, and I'll go into a few details about what that means specifically. And then you're also giving up ownership of the, probably going to be your main asset. So once it belongs to somebody else, it's then open to other third-party risks that you might not have thought of. If your daughter were married and that marriage was to break down, then your house, which now is in your daughter's name, is part of her estate, could fall into her divorce proceedings. That could rock the ship on your ability to live in your own, or what was your house. If your daughter got into financial difficulties, creditors could come snooping around the house to see if that was an asset that they could get to settle your daughter's financial issues. And of course, if you're none of those things, but if your daughter passed away, then your house would be part of her estate and would pass through her will. So depending on where her will, if she has a will, that is, where her will leaves her estate, the house would then go there too, which the recipient of the house, might not be so willing to allow you to carry on living there. So it's just it's nothing Co-op would ever recommend you moving your house into the name of someone else. You're just losing all of your security for no benefit. There's tax implications with those too. I mean, we don't, at the beginning, Ellis mentioned that we don't give tax advice. So what I'm about to say is not advice, it's just stating the tax rules. But we're all aware, well, maybe we're not, but on your own house, when you sell it, any rise in value that it's had is you don't pay capital gains tax on that. You don't pay any capital gains on your own property, your primary residence, when you sell it. So if you run the scenario through where you've placed your house into someone else's name, then the owner of the house, especially if they don't live there, you lose that capital gains relief. So eventually, if in years to come you decide to move, there's potentially a taxable event there, because if the house has risen in value to a point where that gain is now chargeable, even just moving could trigger a tax charge, because you don't have that, the owner and the occupier aren't now the same person. So there's knock-on effects for tax too, just to consider. So but yeah, it might not be the answer that you're looking for, but it's generally speaking not something that we'd recommend that you do. I'll just touch on that deliberate deprivation of assets as well, just to sort of explain what that is behind it is moving assets out of your name in order to try and avoid them from being used for care fees. If you can liken it to the laws around insolvency and bankruptcy. If a person can see insolvency or bankruptcy coming, and then they start shedding assets to other people in the hope that when they do file for bankruptcy, those assets will be safe because technically they don't own them. There's similar laws which say you're not allowed to do that either. You're depriving yourself of something when you can see something coming. So for care, that's how the deliberate deprivation rule works as well. So if something's foreseeable and you're trying to move something away to avoid it, that's when you're not allowed to do it. There's no time limit either that the local authority can go back and look at when you did it. So say you did happen to end up going into care and the local authority was assessing your financial means to see whether or not it was going to help with your care costs, or if you were going to pay for them yourself. There's no time limit as to how far they can look back as to what you've done. So one of the things, if someone didn't have a house, the local authority would inquire as to, have you ever had a house? And if you did, what happened to it and when did you get rid of it? So it's quite far-reaching powers, far-reaching sort of like investigative powers that the local authorities got. So they can go as far back as they need to try and see what happened, what you did and why you did it. And essentially all that happens is if they deem it that you did move that asset to avoid it being used for care and basically say deliberate deprivation of assets occurred, what they do is they just still assess you as if you still own it. So even though you don't, they'll assess you as if you do, which will put your assets up to, depending on the value of the house at the time, but it'll put your assets above the limit where the local authority will give you help to pay for your care. And that could put you in a really difficult spot, because they're going to assess you as if you still have the asset. Of course you don't, but that's going to mean they're not going to give you any help. And if where you've moved the asset to, if they're not willing to help you either, you might have left yourself in a situation where you've now not got assets to pay for your own care and no one's going to help. So it's quite a dire situation you can find yourself in. So just to get a bit of extra info behind deliberate deprivation.
Thanks, Ben. I'm sure it's an area that actually, a lot of people are considering. So I think, it's good to get that clarity on that situation and make sure people aren't falling foul of that particular law. So the next question, it's linked in a way, it's around inheritance. So Lindsay in Bromsgrove has asked, how should we manage the ownership of our homes to secure them for our 2 children and grandchildren?
Okay. So what we were speaking about in the last question was moving your house out of your name whilst you're alive and giving up that ownership. So, hopefully I've covered off that that's something Co-op would really never advise you to do for care fees and all those reasons. This question is more leading down towards what can you do so that after you've died, your property is protected for your, children, lower generation. So we're now talking about wills and trusts that you can place into a will to help those things. So that's actually not deliberate deprivation of assets. That's perfectly fine. So sensible planning through the use of wills to make sure that the property is passing in a way in which it's going to reach your intended children, grandchildren, lower generations. You can do that through a will, and it's often by using a trust. So I'm just trying to paint a bit of a picture, but if you say were a couple and you made wills which were just sort of non-trust wills, just sort of what we call standard mirror wills. Any of you watched Martin Lewis on Tuesday, you'll have heard all about this, but a mirror will just leaving, say, your estate to each other as the couple, and then on second death, when the survivor of you dies, it then passes to your children. That's a really straightforward non-trust will, which is fine. But the risks there is that if everything passes into the ownership of the survivor, it's all then at the risk of possible third-party events. So you never know. There may be later life romance and that survivor might meet a new partner. And then there's the potential risk that what they inherited could find its way to this new partner, especially if they marry. Marriage revokes a will. So say these mirror wills that this couple made when they were alive, first death passed everything to the survivor, so the survivor's will is still there, passing everything to the children. But if the survivor marries a new partner, that marriage will revoke that will, so they'll now not have a will, and it'll be open to the rules of intestacy, which I think there's a question on later, so I'll get into that then. But that's basically what it's called. They're the rules that apply if you die without a will. And the main beneficiary, depending on your estate value, if you die without a will, if you're married, is your spouse. So say if that survivor dies before their new spouse, what they inherited will pass to that new spouse, and that new spouse may not then leave it to the original couple's children. So that's called what we call sideways disinheritance. Your own children can be disinherited sort of sideways by the estate going to a new sort of spouse after first death. So that's one thing, that's a risk, where if you do pass everything to each other on first death, that could occur. the survivor could go into care, like we just spoke about, and obviously if they're holding everything, all of that can be financially assessed. And if it's, I mean, the threshold for the local authority not to assist you is you need to have assets over £23,250, very specific figure. But you know, you're going to be over that if you own a house. So the cost of care these days being, you know, say on average high hundreds to £1,000 a week, you know, care can erode into an estate value quite quickly. So that's another risk. Or there's things like, you know, ill health, you know, incapacitation, lots of things can happen to that survivor. So one of the ways in what you can do is you can, rather than having mirror wills that just pass everything to each other, is you can have a trust will. So rather than passing everything to each other, you put your the assets of the first person to die into a trust in their will, which benefits the survivor. So, you know, in real life, on the ground feeling, nothing's really going to change. They're still going to live in the house and be able to use and enjoy everything. But crucially, what they own is only their own half of what they had. They didn't actually inherit anything legally from the first to die. It's been held in trust for their benefit. So then if the survivor does has the, you know, the remarriage issue, not everything could get lost. It's only what the survivor held on their own might go to this new spouse. The first person, you know, to pass away's assets are protected in the trust. Same for the care fees. And the reason why it's not deliberate deprivation of assets is because, say the survivor goes into care and their financial assets are assessed, if they see that some of the house is held in a trust, the key difference is who set the trust up. And the person who set the trust up is the person who has sadly passed away. The person in trust didn't deprive themselves of any asset. You know, they still hold the half they've always held. It's just they didn't inherit the deceased's half. And that's why will trusts are always the preferred method, because they can never ever fall foul of that rule. So to answer the question, it's that sort of planning basically. For your property, there's two ways to own a property jointly, joint tenants or tenants in common. And the way that the will trusts work is for you to hold your property as tenants in common, which generally speaking, if you're seeing someone about making wills and making trust wills, they'll make sure that that's the case. So it's not a separate thing you need to do. That'll all be done part and parcel of the will writing process. But hold your house as tenants in common. It means your half is your own half, and it'll go into whatever your structure your will creates. And then on first death, it's nice and protected. And then regardless what happens after first death with the survivor, you know that share is going to pass to your children, because it's locked in after first death, and that's where it'll go. And fingers crossed, you know, nothing of those risks will happen to the survivor. And then when they pass away, again, their share will then, everything will go to the children at that point. So you can build the protection into your will with trust wills.
Right. Thanks, Ben. I can see there's lots of questions coming in the chat to follow up to that, so we'll have some for later as well to save.
No problem at all.
I'm going to move on next to another big topic that came in when we asked, when we let people know we're doing this session around power of attorneys. So before we get into the two specific questions, I suppose very quickly, Ben, what is a power of attorney?
Yep, power of attorney is a document that takes effect whilst you're alive. So contrast it to a will, where a will has no effect whilst you're alive. A will just deals with what you want to happen after you've died. Lasting power of attorney says what you want to happen whilst you're still alive, if you've lost the capacity to deal with those things yourself. And the two never meet, because when you die, if you have a lasting power of attorney, it ends on your death and your will starts. So they're not like interchangeable documents or have anything related. One's effective whilst you're alive, one's effective after death. And a lasting power of attorney is a document in which you can state who you'd like attorneys to be, or people who are able to deal with your affairs if you're unable to. There's two types, one for finance and one for health, and you can have either one or both would be the recommended approach, so you're fully covered. And in them you can name your attorneys, and if you're unable to deal with your affairs, then they can basically be you in those decisions. They can speak to doctors, they can speak to banks, and effectively they'll be treated as if they are you. And the key thing to remember, or to reassure people, is that when your attorneys are acting for you, they have to act as if they are you. They can't make decisions in a way of what they would have wanted to have done or what they think's right. The Mental Capacity Act of 2005 is what governs powers of attorney, and there's a really well put together document called the Code of Practice of the Mental Capacity Act, and that basically it's a booklet which attorneys can refer to if they need help, and it's a really good guide on how they're supposed to act when they're making decisions for people, and it's always a best interests decision, and it explains to them what a best interests decision is and how they go about it, but they always have to make the decision in the best interests of the person they're acting for, and always as if what that person would have done. So it's some reassurance for people that it's not anything scary or risky, and attorneys can do what they like. They really can't. The Office of the Public Guardian is the court that oversees them, and any attorneys that get reported acting as such, the Office of the Public Guardian quickly remove their power. So it's very, very controlled, and it's very, very safe. But it's the thing that a lot of people overlook. But when you ask the question of what would happen, if you suddenly lost capacity, you might be minding your own business, safest driver in the world, but someone else might not be, who might hit you and put you in a coma, where totally out of the blue, what would happen? Who's being able to access your money, pay your bills, keep everything afloat, talk to doctors about your health? Because if you haven't got one of these in place, a lot of people think, oh, my spouse will be able to speak on my behalf. They can't. Next of kin's a great one. Everyone's heard of that phrase. They think it means something. It doesn't mean anything. There's no legal thing of next of kin in England and Wales, at least. So there's literally nobody who has the right to deal with your affairs. So unless you've got a lasting power of attorney in place, the alternative route is the people who are trying to look after your affairs will have to apply to the Court of Protection for Deputyship, which takes far longer and costs far more to do, and it's a court process where the court ultimately decides actually who gets appointed. So people kind of apply to the court to say, I'm trying to take over this person's affairs because they've suddenly become incapacitated, they didn't have a lasting power of attorney, but we need to deal with their assets. That alternative deputyship route, whilst the application's going, nothing can still be done. So it could be a good year of nothing being able to done with your assets whilst the court's deciding who gets to be deputy. And even when they do decide, that deputy's under strict reporting rules to the court, where they need to report every year on what they're doing. They've got to pay a bond into court to insure themselves as if they get anything wrong. It's really, really just, you'd want to avoid having to put anyone that you love down that road. So having a lasting power of attorney avoids all that.
Right.
Yeah.
So the next question then might be a quick one for you based on what you said. And this is coming from Scott in Nantwich. At what age should my partner and I start to consider setting up a power of attorney?
Yeah, never too young, really. It's you never know what's around the corner. Like I mentioned, the example of a car accident. There was an example on the TV on Tuesday with Martin Lewis, where someone wrote in and said that they were they're in the 30s and they had that. They were hit by someone, and his partner unfortunately had brain damage after and never fully recovered. Needs carers and doesn't have capacity to deal with their affairs. Didn't have a lasting power of attorney in place and had to go down that Court of Protection deputyship route, which he was just sort of basically saying it did take a long time, did cost a lot of money, and if we just had a lasting power of attorney in place, it just wouldn't have been a thing. I'd have been able to start acting immediately and we wouldn't have had a problem. And they were 33, so it's I think Martin Lewis joked that he did his in his 30s, which was only a couple of years ago. Of course, he's far more than a couple of years away from 30. But yeah, it's kind of like you're never too young if you've got accounts, bills. I mean, people talk about the finance one. Sorry, you said a quick answer. If people talk about the finance one, because that's the thing. I don't know why, but it sort of strikes a chord with most people because your money's important to you, and you've got to pay your bills, and you've got to make sure that everything's in order. But I always say the health one is arguably if you're unwell and you're incapacitated somewhere and someone else is having to look after your health, I probably wouldn't really have my phone bill or my mortgage payment as something that's high on my priority. I want my health to be being looked after by someone that I loved, and I'd want my wife to be involved in the decisions. So like, don't so as far as age is concerned, you might attribute finances to age, because the younger you are, the less assets you have. So why would you need people to, be able to speak on your behalf with regards to your finances? But you've got your health all through your life, so that kind of even rings more true that at any age you should, if you've got somebody who you would name as your attorney, do it. There's no time like the present, really.
And I'd imagine probably the same answer in terms of writing their will. You're never too young to write your will as well, I'd imagine.
True, yeah. There's a legal age limit of 18, so you need to be 18 to make one. But true, it's not based on having anything. People might not think they've got things, but everyone has an account with something in, or clothes on your back, assets, chattels. Chattels is like the legal term for things, maybe a car. So that's one thing. I mean, where your assets pass is one thing that you can deal with a will, because if you don't have a will, like I mentioned before, the rules of intestacy would kick in, and that dictates where your assets go, which you're not in control of. The government set the intestacy rules, and it's like a flow chart pretty much through your family. And then if you've got no family who are alive when you die, then it goes to the Crown after sitting dormant for 30 years. But you might want to benefit charities or churches or universities, good causes, those sorts of things, and intestacy doesn't cater for any of that. And intestacy doesn't cater for unmarried partners either, which is the most crucial thing, because people in relationships not marrying is a lot more common today than it was 50 years ago, and the intestacy rules make zero provision for an unmarried partner, which shocks a lot of people, because you think, well, if we're an unmarried couple and if one of us die, we expect it to just pass to the other person. It won't. If you die without a will, the intestacy rules will pass the person who's died's assets to their family members. And the story that struck me the most on that one was a couple who'd been together for 30 years and never made a will, but never married either. And the gentleman was a baker. He had a bakery, little small chain, 3 bakeries. They were all in his name, and his partner. Well, they were of retired age at this point, and he passed away out of the blue, and they didn't have a will. And his estate was around about 3 million with these bakery businesses, but his closest living relative was one niece, which he'd never really met, and that's who his estate was passing to. So his partner was all of a sudden just completely disinherited. I mean, there's ways in which a claim could be made, and that she could make a claim for that something but should have gone away, and that would then entail a whole litigation process, the courts, etc., which is for the sake of a couple £100, they could have made a will that just left everything to each other, and that was that. So unmarried couples, that would be younger people as well, tend to be in an unmarried relationship, so wills would help there. But for young people with children as well, in a will you're able to state who you'd like your guardians to be for your minor children, which is extremely important to people. So that could be a reason to make a will as well.
I was going to say, so on that point, and you might have covered it. So James in Invergordon asked, without a will, would your estate automatically go to your wife or husband if you are married?
Some of it would, yeah. So up to a value. So the way it works at the minute, and this is one of the things that changed, I think it was like 3 or 4 years ago. So my point being that the government can just make a change, and the intestacy rules will change out of your control. So if you're married and you don't have children, then if you die without a will, everything will go to your spouse. If you are married with children, then it's all about value. So the way it works is everything up to a value of 300, I don't know where they get these figures from, by the way, 322,000 passes to your spouse. And then any value of the deceased's above 322,000 gets split in half. One half also goes to the spouse, and then the other half goes to your children. So the case I had was they were a married couple and they had kids, and the house was in the gentleman's name. It was about 650k house, and had a will. I thought they had a will. And interestingly, I got the estate to administer, and I was presented with the will, and he hadn't signed it. It was a W.H. Smith's make your own will at home. He'd written it all out. It was, he'd really gone to town with his wishes. It was witnessed. So I was like, what were the witnesses witnessing? Because the guy never signed it. So I had to break that to the widow to say there's actually no will. So the intestacy rules apply, and because of the size of the estate, everything's not passing to you. We're way over the 322 threshold. So 322 is going to you, and the rest splitting half, half more is going to you, and then the other half's going to your kids. They had 2 kids. So that left the widow in a bit of a scary moment, because she realized then that the house ownership was now split between her and her 2 kids. And it was a great family. They all got on. So it was lucky, because in my business especially, we get a window into thousands of families' lives each year. And, it's often not the case that it's all roses and everyone gets on. But for this family, it was okay. And the children were great about it. And they both executed what's called a deed of variation. And they varied the intestacy rule to direct what was going to them now back to their mum. So the end result was it all did passed to mum, and it was all okay. But it's a bit of a shock for mum to find out that there's no will. It's actually going like this, and we had to do all this extra work to get it to us. So if you're married with kids, that's what happens. If you aren't married but you've got kids, it all goes to your kids. But then if you're not married and you don't have kids, that's when it starts cascading sort of like through your family. So with it'll go for first things, it goes to your let's have a look, parents. So if you don't have a spouse and you don't have children but you've got parents alive, it'll go to your parents. But then if you don't have parents, then it'll go to your siblings. And if not your siblings, their issue, nephews and nieces, and it keeps going down till eventually we get to like aunties and uncles, and then we get to the cousins, and it only goes down a level if there's nobody there. So the minute it gets to a level of your family where there's somebody, that's where it will fully get distributed. It won't keep cascading down your family. But you can see for people who don't have parents, siblings, so they won't have nephews and nieces, maybe their parents are only children, so they've got no aunts and uncles, so they've got no cousins. That's when they have nobody under the intestacy rules, and it'll all pass to the crown. But you can get some crazy intestacy cases. I had one once where we were at the cousins level, and there was 96 of them, and we hired a finder firm to locate all this person's cousins, and they were all over the world: Australia, North America, Canada, New Zealand, here, and Ireland. And we had to contact them all, ID them all, and then write them a letter to say they were getting 1/96th of an estate. But and the family tree was spread across the office. We can imagine like A4 pieces of paper all stuck together. Yeah. It was the length of the office. All these cousins. But that's what the time, the time and energy and all that sort of stuff. If just make a will, saves all that. But yeah.
I remember there used to be a TV show called Estate Hunters, which I used to watch. Did that tracking down? I think it was always interesting.
That's exactly what they did. So these unclaimed estates, they'll track down a relative, and then for a fee, they'll disclose to that relative, oh, you're set for an inheritance. But that's exactly how it worked. Yeah.
Okay, so I've got one final question, and it's probably got a really complicated answer, but I know we've got to get to Matt to talk through all things around life insurance. But
I'll speed up.
That's right. Can I have a will that covers both Scotland and English assets, or would I have to do 2 separate wills?
Yeah, 2 separate wills. So what catches many people out is the legal jurisdictions that we live in. We all think it's the UK, and we travel to Scotland, we travel to Northern Ireland, Wales, and you know, nobody's showing passports and stuff. We just think nothing of it, but you're actually crossing different legal jurisdictions. So England and Wales is one jurisdiction, and that's where we operate within. Scotland is its own legal jurisdiction. Northern Ireland is its own legal jurisdiction. And as far as succession is concerned, and wills couldn't be more different. It's crazy. Scotland's succession laws are, well, forced heirship for one, so you have to leave your estate in a certain way to certain people, and as opposed to England and Wales, where you can leave your estate to whoever you want, however you want. So yeah, there's no like catch-all will that, but that covers the two jurisdictions completely. But based on your circumstances, go and get advice in the two jurisdictions, and you'll be able to find out if you actually do need separate wills. And the only reason why I say it is because if you're, say, based in England and Wales, say you're domiciled in England and Wales, where you have the testamentary freedom that we enjoy in this jurisdiction, because of that freedom, if you, say, just had a property in Scotland, it may be the case that Scotland will just recognise the English will, and it's not too much to just do it in the one will. But if it's the other way and you live in Scotland and you're domiciled in Scotland, then it's more likely the Scottish rules will apply, and then you may need to have different wills. So it's all about your situation and the assets you hold and where you hold them. So it's definitely not as simple as, yeah, it's one will, crack on. It's go and get advice in both jurisdictions and find out what you need, and they'll direct you from there. So it could be one will, but it's probably going to be two wills. Most of the clients we get, you know, we recommend the two will approach, and then you've got them drafted in accordance with the laws of the jurisdictions they're going to be used in.
Brilliant. Thanks, Ben. Right, I'm going to give you a little bit of a break because you've been talking for a while, but obviously loads of questions coming in, which is really good. There are plenty of questions in the chat if you feel like answering some of them, if they're a little bit simple, and then obviously we've got the Q&A later. But Matt, I'm going to ask you to just introduce yourself and what you do, and then we'll go on to some questions for you, if that's okay.
Yeah, of course. Thank you, Alice. So nice to see everybody. I'm Matthew, and I am a partnership development manager at Co-op. So I look after our insurance products, including life insurance.
Great, thanks, Matt. So hopefully a nice and simple one for you to start with. So this is coming from Yvonne from London, which is my mum's name, and I'm from London, so I hope it's not my mum. At what age, Yvonne asks, is it time to start thinking about getting life insurance?
Yeah, thank you. So it's a good question. So the short answer is there's no correct age. It's more about whether someone depends on you financially. So a time to think about life insurance is you've got a mortgage, you have children, or you share finances with a partner. So it really depends on your circumstances and your responsibilities. So it can be helpful to ask yourself, if I were to pass away tomorrow, would somebody I care about be financially worse off? If the answer to that is yes, then that's normally the time to start thinking about life insurance for that peace of mind.
And is there a minimum age to take out a life insurance policy at all, Matt?
So yeah, it would depend on the type of product, but yeah, so there's and normally it's around 18. I should mention there's also an alternative product in life insurance called over 50s life insurance, which is, as the name suggests, is for people 50 and older. That's slightly different. So life insurance is typically about protecting your income should you pass away. Over 50s, it's less about protecting your income, and it's more about leaving a gift for your loved ones, or supporting for bills, particularly around sort of like funeral costs.
Cool. So actually leads on quite well to our next questions. This is from Chloe from Manchester. Is life insurance effective if you become very ill, or only if you pass away?
So the answer is both. So life insurance almost always includes cover for terminal illness cover. So that's standard. It's included within the policy automatically, and that covers you and will pay out if you become terminally ill. So yeah, the answer is both. You can also add on as an optional extra, which is it comes with an additional fee, but you can also add on critical illness cover. So that gives you broader cover for certain conditions that are specified and certain illnesses as well.
I was going to say, yeah, so that was it. We actually had a question in from Jackie from Yeovil actually on that, which is, I suppose, how important is critical illness cover in later life, or as as part of life insurance?
Yeah, so the answer is it becomes more important as you get older, because the likelihood of you getting a serious illness or critical illness, it obviously statistically at least increases with age. So even in later life, the impact of a critical illness, it can disrupt your income, it can delay your retirement plans, and it can create unexpected costs for treatment and recovery. So it offers that financial stability. So in summary, yes, it becomes more important later in life.
Cool. So obviously you mentioned earlier that the difference, so there's life insurance, which I think is often called term, and over 50. So they are two different products, because people might have heard different, when we're talking about life insurance, it's, I suppose, term, is that the normal one?
Yes, term. Yeah, so life insurance is a standard. What most people think about is called term insurance, and there's a couple of options there. So there's the standard payout that you would choose what you want should you sadly pass away, and that doesn't change throughout the lifetime of the cover. But within that, there's also an option to have decreasing cover. So you choose an amount, and that payout decreases over time, typically within or at least aligned to your mortgage repayment. So the benefit of that is to cover your mortgage. So it's a specific need.
Brilliant. Thanks, Matt. And we've had a question from Dave from Enfield, which is my insurance cost likely to rise as I get older?
So yeah, this is a great follow-up question to the very first one. So I'm going to take it as life insurance to begin with, and the answer is yes. So generally, life insurance is cheaper when you're younger. So if you take it out today, it will cost you less than if you waited several years. Good news is that once you've taken out a policy, your monthly costs are fixed for the lifetime of the policy, so it won't go up as you get older. So if you're thinking about life insurance, then generally it's better to buy earlier than later. If we're talking more broadly about insurance and not just life insurance, then it's different for products. So car insurance, for example, typically you pay more the younger you are. You've just passed your driving test, you're not experienced on the roads, but then the premiums will reduce as you get older, as you become more experienced, at least up until the age of 70 and 80, which it will then start to increase again. Pet insurance is completely different. It's not related at all to your age, and it's purely about your pet's age. So yeah, if the question was more broadly about insurance, then it's different by product.
Brilliant. Thanks, Matt. Right, so I think that's all the questions we've had for Matt so far, although I can see there's a couple in the chat, which we might get to in the Q&A. So there's been some polls running, which is really great to see everyone getting involved with, and some links shared and loads of questions in the chat. So Azra, I think I'm going to hand over to you, if that's okay, to run these Q&A portion. We've certainly got a lot to get through, if possible.
Yeah, brilliant. Excellent timekeeping, guys. Bang on. 7:45. We said 45 minutes, so brilliant. Very impressed with that. Yeah, we've got a couple of questions popping through in the chat. I can see Ben typing away, trying to answer a few. So if you do have a question and you want to come off camera and come off mute, raise your hand. Otherwise, pop it in the chat. And I'll try my best to go through that. So I've got a question, which is, so you've answered those two. How many attorneys can you have per person? So that one's for you, Ben.
Okay, so there's not really a legal limit, but there's like a sensible limit. So the LPA forms themselves give you a space for 4 what we might want to call primary attorneys, and then a space for 2 reserve attorneys, because something might happen to your primaries and you've got some reserves to step in. Advice wise, you'd probably say even that might be too many, because it's all about getting things moving, and you don't want to sort of clog it up with too many cooks type situations. So generally speaking, if you've got 2 or 3, that offers a good mix. And then you if one of them is away on holiday or for whatever reason can't act, there's others that can step in. So generally speaking, if you've, I mean, one's fine, don't get me wrong, you don't have to have 2 or 3, but if you've only got one, then if something happens to them, you've like lost the power of attorney. So usually having a couple or at least a backup in there. So but I wouldn't put too many in, because then it might boil it down to not actually getting anything done because they can't agree type thing.
Brilliant, thank you very much. I'll go to you then next, Matt. Try and yo-yo this. So we've got a question: can I get life insurance in the UK while on a student visa, and what should I know before applying?
So normally, yes, it depends on the insurer and the provider though. So I would definitely check who it is and make sure that when you're filling it in that you're answering the question correctly. So I think probably the thing you need to check is that yes, that particular provider will cover you for that, because it does depend on the type of insurer.
Okay, brilliant, thank you. Then back over to you, Ben. I'm not sure if you've answered this one in the chat, but I am a widower with 2 children. If I die without a will, I assume that they will inherit everything.
Yeah. So no spouse, got kids, they will, provided the intestacy rules don't change. The other thing as well that I'd say about having a will helps is things can get going straight away. So in your will, you get to a point who your executor is, and that's the person who's got the legal right to get on with administering your estate, contacting banks, closing down accounts, contacting HMRC, DWP, all those sorts of things. So with a will, the added benefit as well is, so even though you could say, well, if I make a will that just leaves everything to my kids, what's the difference? The difference is the executor, and the power's there from day one, so they can get that will and get on with it. When you don't have a will, nobody is going to deal with your children until they've gone through the probate registry, applied for what's called letters of administration, which is the same as grant of probate, but what it's called when you don't have a will. And only then, when they've done that, can they go to banks and start doing things. And usually, generally speaking, the time frame of getting the ball rolling, getting to the registry and getting those letters of administration back has been as long as 6 months. It's come down now because they've caught up with the backlog. It's about 3 months. So not being able to do anything for 3 months might not be ideal. With a will, the executors can just get a death certificate, get the will, and get on with it. So I'd always recommend, basically, there's almost never an argument to just not make a will. It's generally better in every scenario.
Excellent, thank you. And then again, back to you, Matt, on life insurance. How do you know how much to insure yourself for apart from mortgage repayments?
Yeah, so this is a really good question, and it's a challenge for most people getting that number right. The best advice I can give is a lot of providers or a lot of resources online offer what's called a calculator, which allows you it will prompt certain questions that helps understand your individual circumstances and what the gap would be if your income was to go, and then that will feed in an answer that will hopefully give you an idea of what cover you could do. So that would be my recommendation. Yeah, use online resources, a cover calculator. Most providers offer one that will help you find the answer to that.
Brilliant, thank you, Matt. A really good question, and one that I can resonate with from Claudia, for you, Ben, and I guess for anyone in the room who might be able to assist with this. But how would you convince an older person, 70 plus, who needs to set up a will to do so when they're resistant? So what works when someone thinks they don't need one, or they think they know what's best? I think as well, it's a conversation that people don't like to have as well, similar to funeral plans and wills and wishes. Do you have any steer or guidance on that?
Generally, I always try and find the root of what the resistance is based on, because that's something you can generally then start to unpick. So if you can find out what it is that's causing them to not want to do it, start from that and then kind of build outwards, because generally there's other than just people just not wanting to face it and admit that it's something that's going, we all face, and you get over that hurdle. All I can say is from experience, and one of the great things I get out of my job is, some people think, oh God, how can you're surrounded by wills and people dying and it must be horrible, your job. It's actually completely the opposite, because we get to help every client put their affairs in order, and it's one of those like cathartic experiences where after it's just like this uplift of, oh, I'm so glad I did that. It's a load off my mind. No one ever finishes it going, God, that was horrible. I'm glad that's over. Everybody is just feels so much better for having done it. So it's just to reassure you that the process isn't like a dour one. It's actually quite thought-provoking, because most people don't think of everything that like a professional advisor would bring to light and think, oh, have you thought of this, have you thought of that? And that's again one of the added benefits of doing it. You finish it for thinking, I'm so glad I did that, because there was so much stuff I never even considered, but now I'm even more settled because I know that all that's sorted out. So start by trying to identify what exactly is the resistance to it, but other than that, just try and just reassure them that it's like for the best. It's only a good thing. There's no, because things can get into a mess like after quite easily if things aren't put in place. So it's kind of like, if they're not going to do it for themselves, do it for their beneficiaries. You make it so that process isn't going to be, at the potentially a horrible time for them too. You're going to be grieving, plus everything's a mess, and they've got hurdles to jump over, hoops to jump through, a complete headache. It's if not for yourself, put it into order for your family's benefit, so that they can not get stuck in those things when the time comes. But if anyone else has got any tips, by all means, pop them in the chat or say.
Yeah, definitely. I feel like there's I know the team have done research in the past where it's shown that people know that they need a will, but there's just this inertia of getting it done. And like you said, it stays on the to-do list, or people put it off. But you're so right, that feeling of completing it, yeah, it's important to do so. And interesting that in the poll, we only 35% of people in our poll today have got a will in place, which is, I think the average that we've looked at across the UK is 40%, so there or thereabouts. So yeah, there is that gap in terms of people acting on that need. Okay, we have a question in the room, hand up. So Catherine, would you like to ask your question? If we can.
Hi.
Here we go.
Hi.
Thanks, Azra. I've got another question for Ben, please. So I'm a relatively younger person. I don't have any complicated property or mortgage payments. I basically just have money in the bank, and I would want to leave it to one person. What's the value of making a will with co-op rather than writing it myself at the bottom?
Oh, right. Yeah, definitely. Okay, so a homemade will it can just be fraught with problems, because it's quite, just to give you some examples, there's a way of phrasing in wills to remove like any and all ambiguity. So a really great example is when people talk about savings and investments. They can be say, oh, I'd like all my savings and investments to go to so and so. When you actually stop and think about what savings means and what investments means, especially in today's world, pack of Pokemon cards could be an investment. So could a shares account. Savings could be your oversized Jack Daniels bottle in the bedroom full of coins, or it can be an ISA in a bank. Whiskey can be an investment. Watches. It's so easy for it to be vague. It then fails through the fact of uncertainty, and then that's when the homemade will pretty much just gets ignored. It's not clear, and the intestacy rules will kick in because you've technically died without a will. So I'd always recommend getting a will professionally drafted, just to avoid all of those potential pitfalls, because it's very easy to word something unclear and it then not be successful. So that would be my advice.
sorry, Ben, I was gonna come in there as well, and not that we're not here to completely promote a card, but there are, is there free will writing months as well throughout the year for people that can access that as well in certain areas?
Through charities, yeah. There's definitely free will month through charities, and then you can probably see how it works is the charity itself doesn't write the will. They partner up with firms, and we're partners with numerous charities, so you can gain a professionally drafted will through utilizing the free will month, especially through the bunch of charities that offer them at this time of year.
Excellent, thank you. Back in the chat, we've got Victor from Bristol. He's explaining his current life insurance policy and how it's been rising annually and really expensive premium for him. He's wondering, is there any way he can reduce that premium without reducing the sum insured, as he's obviously paid a lot of money over the years, and he's expecting that to remain the same after the sum was capped at 75. So one for you, Matt.
Yeah, I saw your message, Victor, and yeah, sorry, that is significant increases. My recommendation would be to speak to the insurer. So insurers typically have a few options that you can do, such as holiday payment, and they can look at ways to reduce the cost, including reducing the sum insured. But yeah, I would definitely recommend speaking to them, because they're significant increases.
Brilliant, thank you. Well, we're coming towards the end of the session, so I'm trying to think if is there any question, Matt or Ben, that you've seen that you want to answer, that you can answer quickly in 30 seconds that's in the chat?
So there's one here that says, are all these rules just for England and Wales, or do they apply to Scotland too? Yeah, Scotland has their own version of pretty much everything I've spoke about, deliberate deprivation of assets, all that sort of stuff. They've got the same rules in Scotland. They have different levels of when care would kick in, as in like it's 23,250 in England, it's 50,000 in Wales, so a bit more generous in Wales. Not sure what it is in Scotland, but I know it's not the same as us, so they are broadly the same across the jurisdictions. Yeah, but check out in each one exactly what it is if you are based in Scotland. I put a link in the chat about our services that we do assist for Scottish clients, so if you can go on the Co-op Legal Services website, and we do have a specific section devoted to Scottish issues, so we can find out there.
I saw a question, Azra, which I was going to ask because I was actually intrigued with the answer as well, which was it's from Ingrid. Can a solicitor act as an LPA, Ben, and also as an executor of the will?
Absolutely, yeah. Like I say, the two aren't connected. So when you say can they act as an LPA, if you mean can they act as an attorney in someone's LPA, like say if they don't have family or friends that they're appointing and the solicitor offers that service, yes, they can act as an attorney, and then whilst that person's alive, if they need assistance, the solicitor can act for them. When that person dies, the LPA ends, the will fires up, and if they're executor in that will, they'll then act as executor and administer the estate and pass the assets remaining to the beneficiaries. There was one question that did come through, I think before tonight, which said something like, I've got no family or friends, I don't know who to appoint. I've seen I can appoint a solicitor, but surely an attorney is going to need to do things like go and get me toiletries, all that sort of stuff. I can't see a solicitor doing that.
Yeah.
All I'd say is there's loads and loads of companies out there that do offer an attorney service for people, so you don't just have to use solicitors. There's you can do an internet search. So if you're in a position where you don't have a family or friends that you can appoint, you're not just then left with solicitors. There's stacks of companies. They'll come out and meet you. They'll go through your likes, dislikes, your personal circumstances, and they'll get to know you on that level where they will be able to go and do those things for you. So there's loads of services out there for you.
Brilliant. And then there was this question as well. Sorry, Azra, for this one. I know I said we're slowly running over, but as long as we're all still here. You might have covered this in the anecdote you told earlier, Ben. But Stanley asks, if a will was not officially or legally made on time, but only a draft person exists, does it help anything?
No, like an unsigned will isn't a will. So a draft that's not signed isn't a will. The person would then be deemed to have died without one. Or if they've got an earlier will, that this draft will that they're trying to make hasn't been finalised, so hasn't revoked, because when you make a new will, it revokes your last will. So if they've got an earlier will, that'll still stand. If they don't have a will, they'll be deemed to have died without one. All it may help with is if because the intestacy rules are going to kick in and pass that person's estate to whoever their family as its structure is. If people want to do the right thing, if they want to honor someone's wishes, they've got this unsigned will that was reflective of what they wanted, they can do deeds of variation to vary what they've received through intestacy to honor the will, but they have no legal obligation to do that. If they're inheriting through intestacy, it's theirs by right, and they don't have to do that. So it's just an unsigned draft isn't a legal will. No.
Brilliant. Thanks. Right, Azra, I'm going to come to you to announce the winner from all the attendees of the £50 on their membership card, and then I'll just wrap up for the evening after you, if that's okay.
Yeah, brilliant. So the winner, we've picked a winner randomly selected who will get £50 onto their membership card. So congratulations. Our winner is Peter Keeble. So your card will be loaded with 50 quid spending the co-op. So congratulations and thank you for joining. And yeah, Ellis, I'll let you wrap up the evening. Thank you.
Thanks, Azra. So I think it's been a really good session. Thanks to everyone for their questions today. So our next online Ask the Expert event will be held in June. The date and time is still to be confirmed, but we'll email members in our joining email on the 23rd of May. So please keep an eye on that, and obviously the other activity you can join in on. Keep your eye out on the Co-op membership emails on the Co-op app later this month for more with details as well. Thanks for everyone for taking the time to join us this evening. I really hope you found it useful. As I mentioned earlier, it's the first time we've run one of these, but we're looking to run them throughout the year. There is an email coming out on the 12th of March where you can leave your feedback, and we'll have links to the recording as well and find out more information on what we discussed this evening. So please enjoy the rest of your evening in the week, and we hope to see you all again very soon. Thank you very much.
Thank you, everybody.